And now I'm going to totally pivot to talk about when these AI is being used in software-enabled platforms. How do we protect it when there's something innovative? And how do we navigate this evolving landscape called patent law? Because patent law is evolving, and you'll see later in my presentation, I literally had to add something because there was a case that just got decided yesterday. So why this is so interesting to me is our firm focuses, for years we focused on software patents, and we've noticed that more than half of our patent clients in the past year or so have incorporated AI collaboration into their invention process in some way. The two main ways that we're seeing is, for some, they get an idea and then they explore and refine the idea through AI chats. So literally, instead of having a co-inventor that they sit and talk through the ideas and brainstorm, they're brainstorming with AI chats. And the other is where, as we just saw, AI can enable some amazing improvement in an area that somebody is already working with. So we've worked with surgeons, we've worked with career people, we've worked with so many different kinds of fields where AI allows their field or allows them to be more optimized. However, it's raising a lot of patent protection questions. And today I'm going to focus on 3 areas. And actually, Maria had mentioned this earlier. Public disclosure, what you need to know about sharing your ideas. Then we're going to talk about inventorship, who qualifies as an inventor in the age of AI. And we're going to close it out with software platform patentability, how to protect AI-driven software innovations. So let's start with public disclosure of chat logs. And like I said, I've noticed a growing trend. Many inventors are coming to me with ideas they've developed while chatting with AI. Often, as some of my friends know, it's a cuss word for me, ChatGPT. So they're literally providing me with the chat logs and saying, here's my invention. Honestly, I get a little nervous when I see that. So here's why. Those chat logs, if they ever become public, could be used as prior art against a later filed patent. But how can that be if you're the one chatting and you're the inventor? So let's take a step back for those that aren't as aware of patent law. Patenting invention requires novelty. Anything already in the public domain can be considered prior art and used again by an examiner against you getting the patent. Now, in the US, if it's your own prior art, you have a grace period. It's 12 months. So these chat logs, if they became public, well, they're yours. They're your invention. So for 12 months, you're okay. So a lot of people just breathe a sigh of relief. However, not all countries have a grace period. In fact, China and Australia, as examples, they have no grace period. They require absolute novelty. So if it's going to be important to you to have a patent in those countries, or even in Europe, it's not quite absolute novelty, but there's a lot of caveats. So you really need to be careful with that. Now, some inventors think they're getting around it by using private chat logs. And so that is a step in the right direction, but it's not foolproof. And here's why. There is a lot of litigation, as you guys know and have heard, around AI. And what's happening is in the courts during discovery, the judges are making decisions. One is they're saying, hand over all your chat logs, like millions and millions. They don't care. They want it all. And in one case, in I think it was a New York Times case, the judge said, no chat logs can be deleted. So if you were worried about your chat log becoming public and you deleted it, it's not really deleted. And in some cases, it's given to a court for discovery. Is it now not public? Maybe you didn't want that information out there. So you have to be aware when you're inventing using AI of these risks that your information is going to get out there when you don't want it to be out there. So my advice is assume any chat you use to develop your idea could become public. Use AI sparingly during the invention process. Instead, consider filing a patent application on your main idea. And then if you want to finesse it, make it ready for marketing, maybe get some new ideas out of it, then use AI as kind of that next step. And so this is kind of a summary of what I just said. I want to reiterate because it's so important. AI platforms are tools. They are not your confidential advisors. So many people talk to AI like their best friend or their colleague, but we have to remember they are amazing tools. They do amazing things, and that's fine, but they're not your co-inventor, your confidential inventor. So treat your interactions accordingly. When you're developing the concept, innovate privately. Secure your patent protection first. I know I'm repeating myself. And then leverage AI for refinement afterwards. Okay, so let's change topics and let's talk about patent inventorship. And I've been following this for over 5 years because the first cases on patent inventorship with AI were in the 2020. So you can imagine that it's become a very well-developed concept. In the US and in many other countries, and we'll talk a little bit about other countries, AI, not only in our regulations, but in court decisions, cannot be an inventor. There must be a human aspect to the conception. In fact, many, like the US, literally say an invention developed by a human being. Patent offices around the world are saying this. And as I said, there have been multiple cases where an owner, because he said he's not an inventor, an owner of an AI system claimed that the AI, Dabis was, you can look up the cases, but the AI, his claim was that the inventor was solely the AI. And except for, I believe it was South Africa, every court case said no. You must have human involvement and significant human involvement in order to have a patent, in order to have inventorship. So again, AI can be a tool. It can assist, but it cannot create. And inventors need to be able to show that contribution. I'm going to talk in a minute about what are the kind of things you should be documenting to do that. So just to show you quickly, every country is a little bit different from a global standpoint, but still the same thing applies. In Europe, strict human invention is required, right? So I said in the US, significant human inventorship is required. In Europe, it's strict. AI must show a technical effect, but not be part of the actual algorithmic output or the actual technical conception. China, a little softer. They encourage AI innovation, but they mandate human interaction. So in China, you can focus on AI, again, being a tool helping you solve something, but the AI cannot be the inventor. And again, in Japan, and these are just 3 snippets to give you an idea that it's worldwide. In Japan, patentability relies on human contribution to AI's creative act. So remember I talked about how I have all these inventors who are collaborating with ChatGPT? It's that human conception, that human inventorship that is very, very important. It can't be ChatGPT coming up with some new invention and then the person that comes to the attorney says, hey, file this application. So let's go back a little bit. The USPTO has been very good about guidance, not only because of how the regulations and the use of AI have changed over especially the last 5 years, but also based on the court cases and how people are using it. And so the regulations now say significant contribution to conception. So as an inventor, as an innovator, when it comes to conception, ideally it is your idea. It is a complete invention that did not use AI. Reduction to practice, the practical application of the conceived idea can use AI as a tool, but an AI output alone is not sufficient to have human inventorship. And I'm going to talk I'm going to talk next about documentation, because I'm like telling you, well, you need to do this, you need to do that, but what if you're challenged? So documentation along the way as you're interacting with AI could be very, very important if someday later there is a question of inventorship. And I'm going to add something. Again, those not in the patent world might not know this, but the number one most prevalent way that courts invalidate patents is through the wrong inventorship. And from a logical standpoint, that makes a lot of sense, because judges are not engineers or patent attorneys. Juries are not engineers or patent attorneys. But the concept of you got the inventor wrong is easy for a plaintiff to show, right? It's much clearer, much easier to understand. So if you're worried later of a later question of validity of the patent, that documentation could be key. Oops, sorry. Okay, so before I go on to documentation, just I repeat, because I want to make sure. When you're inventing with AI, AI is a tool, not a replacement. Human insight is required. Use AI for assistance, and then you can have collaborative innovation. So now let's talk about documenting. When you're co-creating, documentation is really, really important. So what should you be documenting? The initial ideas you got. You woke up in the middle of the night at 2 a.m. and you're like, oh my goodness, if I could do this, this would be, I'd never seen this before in my industry, and it would be really, really groundbreaking. Write it down. As you're developing it, we used to keep handwritten notebooks that engineers would give me, write it down, type it up, date it, indicate, even sign your conception, sign your pages. Just make sure that it's very clear that you came up with the conception. Document your AI prompts. What did you talk to AI about? Make it so that will make it clear that you weren't gathering the actual innovation from AI. You were using AI just to get some refinement, or to maybe just bounce some ideas off, like you would bounce them off of a colleague who was not a co-inventor. Any human modification you make to AI output. So if AI gives you an idea, but it's really, that's pretty, everyone knows that it exists. But then you go, oh, wait, I have an idea. I think I could do this, this, and this. Write it down, document, put some kind of signature on it, such that it's very clear that this is a human inventor. And like I said, dating things could be important, just in case it's ever. Now, I know that sounds like a lot of work, but if you're inventing something, if you're coming up with a conception, you're going to write it down somewhere. Just keep those documentation carefully. You should be documenting throughout the entire process. Log when you did things, when you talked with, when you chatted with AI, anytime that, from start to when you go to that patent attorney to file a patent application, keep track of everything. And again, as I've said, human interaction must be delineated. So highlight all the critical ways that you, as the inventor, did something. Again, we already know from the course, AI cannot be an inventor. So very important. Okay, now I'm going to switch gears a third time and talk about something that I'm dealing with every day. And so for those not in the patent world, patenting software inventions is already difficult. There's an extra hurdle, which is a human cannot do this activity. That's the easiest way to say it. And actually, this is what I have focused on for the last 15 or 20 years, even before AI was so popular. Just the patenting of software platforms has always been more complicated. And now adding to it AI-enabled software platforms, you can imagine the patent examiners are confused, the patent attorneys are confused, the regulations are changing. There's a lot of questions, not only in the US, but around the world when it comes to it. So simply put, any software, whether it's AI-enabled software or any software invention, has to pass what's called the abstract idea test. This means there has to be a practical application of the idea. So I always like to say, if a human can do it, but AI makes it better, it's not patentable. In the US, it's called a 101, that's the regulation. And we always have to prove this is not an abstract idea. This is not just a method. This is a physical, technological improvement. And that brings me to my next point, which is technical improvement. If something is an AI-enabled software platform, the first thing an examiner is going to ask is, what is the technological advancement? And that advancement can't be, they just made it faster and easier and smarter for us, which AI does. We all know that. We've seen that in the earlier presentation as well. There has to be an and plus this, and plus this. And many of our AI enabled software applications, the way I have gotten them allowed is talking to the examiner and showing the examiner the technological advancement. It's doing something that could not be done before. And that's really critical. And there needs to be a specific application. So we write a lot of applications for a client that's optimizing surgical procedure rooms. And those patents get granted because they are written towards optimizing surgical procedure rooms. You see the difference from just, here's a method of how to do something and AI makes it better. So very, very important to know that when you're looking at your idea. Many of the AI-enabled software platforms that come to us, we have to pull that out of them. They're like, this doesn't exist. It's so great. It's making life so much better. It's so much faster than anything that exists. And then I sit with the inventors and we have to help them to tell us or to develop those concepts of technical improvements, technical advancements, things that humans can't do, and specific applications that they're being used in. Oops, sorry. So the really good news is last year was a great year for me. We have, in the US, we have a new commissioner, John Squire, And last October, he spoke at, he had just been put in as the head of the USPTO, and he spoke at an AIPLA conference. And I was like a fan. You would think that I was at a rock concert because everything he said, I was just so amazed. And since he's been in place, which has only been a few months, the USPTO specifically has really taken a different approach for AI. Actually, what my team and I and many other patent attorneys have been saying is finally coming to be, which is that AI-enabled software can be patented. And just because it's AI, just because it's software, doesn't automatically cut it out. So those 3 areas I just talked about are actually now, the regulations have been updated. There's been a memo by John Squires that points out what can be patented, and it's really what I just said. So really big improvement, and we're seeing already applications that we've been going round and round multiple times with examiners are suddenly being granted. So the tides are turning, at least in the US, really good sign for the future. So here's my breaking news. This is so exciting, right? I'm like, I woke up this morning. Yes, I'm a geek. First thing I do is I look at what's new in AI. And amazingly, we have breaking news. Yesterday, there was a new major ruling by the UK Supreme Court. And again, tides are turning. This is UK now. So what happened is there's a company called Emotional Perception AI. So yeah, all my AI friends this morning were saying today's Emotional Perception Day. And at first I was like, what? What does that have to do with patents? But that's the name of the company. They created an artificial neural network that went through the UK patent system being declined, and it went to the Supreme Court. And yesterday, just yesterday, the ruling came down that a computer program, in this case, specifically emotional perceptions, ANN, can be patented as long as it involves physical hardware. Now, their claim was you have to have physical hardware. You can't, this doesn't work without a system behind it, a tangible system behind it. And for the first time ever in the UK, the Supreme Court has basically overwritten like 20 years of how things have been done. So this is super exciting for our AI platforms that are coming about. This is just the UK, but I told you how the USPTO is changing. Now we have another court, a Supreme Court, who has come down in favor of AI platforms. So I thought that was really exciting. So emerging trends, legislation is still not in place. That you need to watch that. It's changing all the time, the statutory frameworks of how this will be considered. This is like another step from when computer software started, like years ago. Now this AI is the next thing. Lots of litigation, and most cases have not been decided yet. So watching case law is going to be extremely important. Refined guidance. I told you the USPTO has just in November of last year refined their guidance. I presume UK will be next now that they have the Supreme Court decision. And remember to document everything. I think that that's going to be extremely important as these cases become, heard, and hopefully you're never one that's part of that. And I'm going to end with just a repeat, but some recommendations. Maintain confidentiality as you're using AI. Be sure you're not putting your trade secrets, your inventions into it. Focus on the application. Get the right patent application drafted and filed before you go too far. Document your contributions. And because the law is changing, you saw from yesterday when I had the presentation done to today, a brand new, major change. Work with experts. talk to experts. And that is my presentation. Here's my contact information. If you have any questions, definitely reach out.